Thank you all for joining us for the second webinar on Rhode Island's new pay equity law that went into effect January 1st, 2023. If you are not able to be with us for the first webinar, please visit the Toolkits and Help Desk tab on our membership portal to view the initial overview of the law. Today's session is part 2, and we will cover the self-evaluation component of the law. Joining us again today is the expert on the topic, Chris Yagubian from Adler, Pollock & Sheehan. Chris is a member of the firm's litigation group, where he uses his courtroom and litigation experience to advocate for his clients. He supports employers in all aspects of labor and employment law, and these areas include employment discrimination, defending businesses against commercial, contract, and general liability disputes, and advising insurers in coverage disputes. So with that said, Chris, I'm going to turn it over to you.
Excellent. Thank you, Caroline, for that. So welcome, everyone. I'm happy that I didn't scare everyone away after doing the first presentation on the pay equity law. We have a lot to cover today, so I will do my best to get through everything as meaningfully as possible within the time allotted. So what we have first is our opening slide, just kind of outlining what we will cover and what we won't cover. So as a general rule, we're not going to revisit the material covered in the first module just because there's not enough time. As appropriate and when needed, material will be referenced from the first module as it's necessary to understand what we're here to discuss today, which is the self-evaluation. So with that being said, what we're going to do is review the self-evaluation affirmative defense established by the new pay equity law. We're going to review the requirements that an employer has to satisfy before it can rely on the self-evaluation defense. We're also going to review applicable DLT guidance on how to conduct the employer self-evaluation. This is going to, of course, include unpacking the factors and steps associated with undertaking an effective self-evaluation in good faith, which is required to be relied on in the event that a claim is filed. So with that being said, there we go. So a lot of the questions that people asked me last time was, does the Pay Equity Act apply to my business? The Act broadly defines employer, and practically every employer with employees working in Rhode Island has to comply. So that means this seminar is for you if you fall into that broader category. So specifically, the Act applies to all Rhode Island employers, as well as employers that are not incorporated in Rhode Island or do not maintain a principal place of business in Rhode Island, but have projects, employees, or satellite offices located in Rhode Island. If an employer employs any person who works in Rhode Island, fair to say that the new law is almost certainly guaranteed to apply. So it's better to, if you think the law applies to you, it's better to follow its preconditions than to, try to hide behind the, oh, I didn't know. That rarely flies in the legal community. So the Pay Equity Act self-evaluation was recently created, and the self-evaluation component specifically is an affirmative defense for all claims alleging a violation of an disparate employment, or excuse me, a disparate wage practice as it's created under the law. Up until June 30th, 2026, the self-evaluation is a complete defense to all liability, provided that the employer demonstrates that the self-evaluation was conducted in good faith, and that the unlawful wage differentials have been eliminated, assuming any were identified. Once we hit that date of June 30th, 2026, the defense will only be available against liquidated damages, compensatory damage, or civil penalties. One important component to keep in mind is that the law does not require employers to use a specific self-evaluation template. Rhode Island Department of Labor and Training, DLT, as I'm sure most of you know, has issued some guidance, and we even provided a pay equity spreadsheet for employers conducting self-evaluations that is 100% free and available on DLT's website. We this webinar will address and go into details on some aspects of that spreadsheet a little later into the presentation. So, and I apologize for my poor PowerPoint skills. So the self-evaluation and due diligence. The key aspect of performing a self-evaluation is the exercise of due diligence. This requires an employer to look at all relevant jobs and employees within those relevant jobs, and whether the employer's analysis makes a reasonable effort to identify similar jobs and employees using a consistent fact-based approach, and whether the employer has tested explanatory factors for an unbiased and relevant relationship to pay. Effectively, what the due diligence requirement requires an employer to do is take a good look at your pay practices based on the information you're going to collect from your employees and make a reasonable effort to look at those employees, look at the wages being paid in good faith, and then fairly apply authorizing factors as uniformly as possible in order to avoid potential claims that authorizing factors are applied across work cohorts is arbitrary or inconsistent. The word work cohort will be coming up throughout our presentation. And when that term is used, it really just means comparable work or jobs that could be considered comparable work. So one key aspect to keep in mind is the definition of due diligence will differ for a small business with a few categories of jobs compared to a larger or more operationally complex organization. That being said, what would be due diligence and actions taken in good faith for an employer who only has, let's say, 15 employees may not necessarily be considered good faith or due diligence if those same measures were taken by an employer who has 115 employees. So the self-evaluation is critical to defending against any claim of violation. The DLT guidance has broken down the self-evaluation into 6 steps, and we're going to go over each step in pretty comprehensive detail throughout this afternoon. Please note that these DLT's guidance represents their interpretation of the pay equity law. So it's not binding on any matter before the department, and it's not binding on a court and does not constitute legal advice. However, great deference is often provided by courts and as well as the department if in the event you are faced with a claim that you can show that you followed DLT's guidance. So the first 3 steps are really where our focus is going to be today. And those focus on setting up what is necessary to perform the self-evaluation by collecting information from employees and then identifying comparable work cohorts based on the information provided and collected. So the first step is gather information. Again, the definition of due diligence will differ for a small business with few categories of jobs in a larger or more operationally complex organization. The employer's self-evaluations can be of their own design, but I would highly recommend using DLT's one for free, which does do the math for you based on calculations contained within the spreadsheet. So I, before I gave my presentation today, I played around on it for a little bit and thought it could be a really helpful tool just to see how different numbers are calculated and how different categories can be flagged as being potentially problematic based on a disparity in pay. Okay, so the first step to performing an effective self-evaluation is to gather data and other necessary information. Note that additional information may also be relevant depending on a particular employer's compensation policies and practice in the nature of the business being performed. So this is a non-exhaustive list of factors that an employer should be able to obtain with little to no difficulty, with the exception of what is known as the existence of protected characteristics, which we're going to discuss in better detail next. So, in terms of what additional information might be relevant, that depends from employer to employer. If an employer takes job-related training or credentials or individual production or sales into account in determining employee compensation, then that type of information should be gathered as well. As a general rule, employers have access to much of this information. The protective characteristics identified on subpart B include race or color, religion, sex, sexual orientation, gender identity or expression, disability, age being 40 or over, or country of ancestral origin. The biggest hurdle we anticipate employers having is the existence of a protected characteristic. Some of the protected characteristics can be visible or appear to be visible, but others may not be. Those would be, of course, the religion, the sexual orientation, and even nowadays, gender identity or expression. Okay, so if you're an employer who's required to prepare and submit an EEO1 component and one report annually, then you should have access to your employees' gender identity or expression and race and ethnicity, because that type of information is required to be compiled on a voluntary basis. Employers should similarly have access to each employee's age for the purposes of the self-evaluation via the employee's date of birth. The most difficult information to obtain will be with respect to the remaining protected characteristics, which are not always readily discernible. In order to obtain this non-easily discernible information, an employer effectively has to ask their employees for a voluntary disclosure. Now, keep in mind that other provisions of the Rhode Island Fair Employment Practices Act still apply even in the wake of the pay equity law. So one of the key components when trying to get a voluntary disclosure of sensitive information is to only ask employees, because Rhode Island's Employment Practices Act, Title 28, Chapter 5, Section 7 makes it unlawful for an employer prior to employment to elicit or attempt to elicit any information directly or indirectly pertaining to an individual's race or color, religion, sex, sexual orientation, gender identity or expression, disability, age, again, age being 40 or over, or country of ancestral origin. And it also prohibits an employer from making or keeping a record of an employee's race, color, et cetera, at the application stage. So when you're looking to gather this type of information, you really want to be making sure that you're not crossing that line and asking employees or prospective employees at that point voluntary disclosure information at the application stage. Employees should really only request information regarding non-protected characteristics with employees and not applicants.
Chris, I have a question here.
Sure.
In the chat. So the question is, are we able to structure job descriptions or packages to differ from others when it comes to who is eligible for paid time off?
I think that really depends on the specific jobs. A little further along, we're going to talk about what differentiates jobs from one another. Typically when you're trying to look at those types of issues, you want to look at the skill, you want to look at the responsibilities, and you want to look at the experience needed for these types of jobs, because, part of what this law does is ensure that everyone at the same level has an equal playing field. However, that being said, there are authorizing factors that we will discuss a little bit later on that allows an employer to have, a base salary package, for example, for, a certain level employee, and to, have some wiggle room based on one of the factors authorized that would justify a pay disparity. So to answer the question, yes, but it really depends on a lot of the specific facts. So what happens if the employee doesn't want to voluntarily disclose? Because employers should really bear in mind that employees might be sensitive about disclosing personal information to their employers, especially if some employers and employees have, a cordial relationship. So when employers are requesting this type of information, they should expressly tell their employees that providing the requested information is voluntary and will not affect their opportunity for employment or the terms or conditions of their employment. As part of the gatekeeping of this type of sensitive information, employers should, as a best practice, limit who has access to information regarding an employee's protected characteristics if voluntarily disclosed, to maintain the employee's privacy. I'm sure everyone can imagine the type of chaos that could ensue if an employer has, a codex of sensitive information regarding their employee's religion, their sexual orientation, their gender identity, and that being inadvertently leaked or placed in an area that is accessible by all, even if on a virtual platform. Like an EEO-1 reporting information related to an employee's protected characteristics should be kept separate from all other personnel records only accessed by the Human Resources Department. Again, the law doesn't require an employer to put these safeguards in place, but in terms of a best practice and just recognizing that people make mistakes, it would be better if the person who collects and holds on to this information isn't a supervisor, isn't a management professional, and it's really limited to those who have a need to know. And that for most employers that, falls within the Human Resources Department bucket. So now we're going to talk about identifying comparable work. Unless there's a pending question about the first step. Okay. So after we've collected our information from our employees, the next step is to identify what would constitute comparable work. So again, this is going to look different from employer to employer based on how the organization is structured, based on the nature of the business, and the number of employees. So the first step really in this multi-step process is to identify which positions in the entity are comparable. Employers should consider creating job groupings around the skill, effort, and responsibility required to perform a role, as well as the relevance, and importance of the output to the entity's business model or mission statement. Effectively, what that means is employers should create, different categories of job groupings that have like skill, effort, and responsibility. A good example of what likely wouldn't constitute a good job grouping is, a staff member in the same grouping as a supervisor. While the skill and effort might be somewhat similar, the responsibility levels would be pretty disparate between someone with supervisory authority and, just a regular employee doing basic work of whatever it is the employer has. Depending on the employer's business model, they may also want to consider working conditions such as physical surroundings, hazards encountered during the course of a shift, or a shift during which work is performed. One of the classic examples of this that comes to mind is a night differential. Typically employers who work between certain hours during the day will not get a night differential if another employee is doing that same type of labor, at 1 o'clock in the morning. Again, this really does depend on the employer and the nature of the work being performed. One key thing to keep in mind is while job titles and descriptions are useful, they don't alone determine comparability, and even job titles and descriptions that are facially significantly different might be found to be substantially similar if they align along the same vectors of skill, effort, and responsibility noted above. Similarly, an employer shouldn't assume that jobs in different units, divisions, or departments are not comparable unless there's a different skill, effort, and responsibility level associated with those positions. Okay, so we're still on step 2 and trying to identify comparable work. So this is one of the terms that was created by the new Pay Equity Act. And it's a term of art as, we're using it in connection with this self-evaluation. Comparable work is defined as work that requires substantially similar skill, effort, and responsibility and is being performed under similar working conditions. What does that mean? None of those additional terms aren't defined. But what you can do is determining whether jobs are comparable will require an individual analysis of the job as a whole. Minor differences in skill, effort, or responsibility, again, won't prevent two jobs from being considered comparable. Now, I just want to note a distinction here between the Rhode Island Equal Pay Act, the Rhode Island Pay Equity Act, and the federal counterpart, which is the Equal Pay Act. So I just want to note that comparable work as used by the Pay Equity Law is not the same as equal work for equal pay under the federal law. In fact, the Rhode Island counterpart is significantly broader in scope. So what an employer has in place to comply with the Equal Pay Act likely won't be enough to comply with the Rhode Island Pay Equity Act.
Chris, we have a question, I think.
Sure.
Anthony, did you have a question?
I do. Thank you for allowing me to ask this. When you look at the definition of comparable work, I can't help but think about line cooks. And,
right.
Whether or not you have a qualification where you have a grill person, saute person, expediter, cold pantry, hot pantry. Where I'm having a little bit of a disconnect is whether or not if you hire a person as a, let's say, lower level or entry level line cook, and they may have the skill set to go higher, but there's no opportunity to do because the job is filled. Mm-hmm. There is some, I guess there could be an argument that it's comparable work. So I, as an employer, what can I do to protect those levels within maybe a comparable atmosphere?
Yeah, no, that's a great question. And I agree that it's really, the line definitely blurs, in the hospitality industry where you have multiple qualified people who can, in theory, jump in as, line cook 1, line cook 2, line cook 3. But, for the purposes of answering your question, I would try to differentiate the responsibilities between somebody in a lower level line cook position and how those are different than those of a more experienced line cook. And that could be, the shifts being given, maybe a lesser experienced line cook is only staffed for weekdays versus weekend. So those would be the differentiating character, or depending on the dish being prepared. Those are the types of differentiating factors that would likely fall under the responsibility prong, and possibly skill depending. You could have two people who are equally skilled at cooking, and they both can make the best dish ever, but one could be in a supervisory position and therefore have longer hours, longer shifts, more responsibility in terms of monitoring what's being ordered, monitoring what's being rotated, as opposed to somebody who's in a lesser paid position at entry level who possibly could do those types of tasks just as effectively, but doesn't necessarily fall into the same job category description.
Chris, I'm just afraid we're going to go down a rabbit hole by trying to qualify people for whether or not they have the skill set to be at that higher level. And And it just seems like it's, could be both counterproductive and also could, as I look at it, open us up to even more liability.
No, I agree, and that's definitely one of the problems created by the law. One of the things that I would suggest is, instead of focusing on the skill or effort, the differentiating factor, in this hypothetical, would really differentiate the two positions based on the responsibility. Again, product ordering, product monitoring, opening, closing, things that typically a more seasoned person would be responsible for because the employer has trusted them, versus not giving that same level of responsibility or supervisory opportunity to somebody in a lesser position. Yeah. But, I agree. And, especially in the hospitality industry where things blur very quickly, it is a wrinkle. And I do think that moving forward, the differentiating factor as it applies in this type of scenario is going to rely mostly on the level of responsibilities afforded, because that can also coincide with the effort as well and the skill. A different set of skills, sure, but skill and effort just in a different avenue in addition to cooking responsibilities.
Well, I just, and I don't mean to labor this point, but now you're going to run into in non-union houses a union atmosphere which says, "Oh, that's not my job." So you're right. There's a wrinkle here, and I just don't know that legislators really thought this out this way. They're imposing a law which is very difficult for a company that has done business based on the French Brigade system, which is hundreds of years old, where there are similar functions. You come in, you set up your station in a very similar way to the person next to it. So, I just you basically have to rip apart an entire system and rebuild it, and probably have to hire a human resources person to do it.
Yeah, I don't disagree. And I think that, as claims eventually start to roll in, courts are going to be forced to effectively take a position as to what would constitute comparable work in the hospitality industry versus what would constitute comparable work in an office setting. Because I agree.
Thank you, Chris.
Yeah.
Thank you.
Yep. So, okay. So, and again, this may not be a model of clarity based on our most recent discussion, but DLT has provided some guidance regarding some of the key terms that should be interpreted in order to perform a self-evaluation in identifying comparable work. Again, that goes to what I was just speaking to. Substantially similar means that each of the factors being considered, skill, effort, and responsibility, are alike to a significant degree across numerous relevant components, but are not necessarily identical or alike. Minor differences will not prevent two jobs from being considered comparable. And the focal point really is identifying comparable work as skill, effort, and responsibility. But working conditions might also need to be considered depending on the job and the type of business being run. So in terms, breaking apart what skill, responsibility, and effort means, skill includes factors such as experience, training, education, capacity, and ability required to perform a given job. Relevant components are those relative to the the performance requirements of a job, but not to the particular skills an individual employee may possess. This means skills not necessary to perform a particular job are not relevant to determining whether jobs are substantially similar. And by way of an example, the guidance explains that employees doing business work on different lines of business for an employer might be similar. For example, employees selling different types of insurance might be performing work requiring comparable skill unless one of the types of insurance requires meaningfully different levels or degrees of knowledge or expertise. Another example of jobs requiring comparable skill are janitorial and food service workers at an elementary school, as neither job requires previous experience in the field or arguably specialized training. So, again, not to beat it down, but just another illustrative example. Just kind of expound on the last one, janitorial and food service jobs generally don't require previous experience in the field or specialized training, and therefore could constitute comparable skills, even though the substance of the two jobs is entirely different. So the next factor to look at is effort. Effort refers to the amount of energy or exertion needed to perform a job, including exertion that creates physical, health, or mental harm, fatigue, or stress. Now, this can be interpreted to mean that effort refers to the amount of exertion needed to perform a job. For example, a job that requires standing all day would likely not compare to a sedentary job. However, again, going back to the janitorial and food service example, those jobs might require similar effort because they're both up and moving around, generally to perform their job function. A job that requires a person to stand all day likely is not comparable to sedentary. On the other hand, the amount of physical exertion that goes into performing the average janitorial and food service jobs might be either substantially similar or substantially different. And again, that really does depend on the business model, the size of the employer, and the specific tasks assigned to each employee. And I agree that it is at one point kind of splitting hairs based on the lack of guidance. So responsibility. This encompasses the amount of authority an employee has over executive, strategic, and operational aspects of their unit, and takes into account the level of discretion and accountability involved in performing essential functions of a job. These factors, or the responsibility factors, would include the amount of supervision the employee receives, whether the employee supervises others, and the degree in which the employee is involved in the decision-making process, such as determining policies and procedures. So, by way of example, an employee responsible for executing legal documents may have a different level of responsibility than an employee who drafts the documents. By way of another example, at a department store, sales clerks generally are not responsible for sweeping the floors. However, the fact that a sales clerk in the housewares department is occasionally asked to sweep up if a customer breaks a glass does not prevent her from being considered comparable to sales clerks in other departments if their duties are otherwise substantially similar. So the last thing to keep in mind is working conditions, and this includes environmental and physical settings. This can include being exposed to on-the-job hazards, extreme temperatures, either hot or cold, noise, fumes, heights, and other types of dangerous equipment. Working conditions can take into account meaningfully differences in the days or time shifts are scheduled. Again, by way of example, employees on factory floors may not perform work comparable to employees in offices, and jobs performed indoors might not be comparable to jobs performed outdoors. Additionally, employees who package hazardous chemicals may not be comparable to employees who package non-hazardous materials. So, step 3, calculating whether individuals performing comparable work are paid differently. Once the employer has collected the necessary information and identified comparable jobs, the goal then is to compare the wage information to look for differentials in pay within members of a comparable work cohort or group. Again, for an organization with small, clearly defined groupings of comparable jobs and relatively simple pay structures, a simple analysis comparing the average wages earned across comparable jobs might be sufficient to identify where there's a disparity. Again, when the number of employees in a particular grouping of comparable jobs exceeds 30, or if the pay structure is complex, a more detailed analysis will likely be necessary. However, in most cases, conducting a statistical analysis by comparing the numbers and taking across comparable jobs, while taking into consideration the prohibited characteristics, will likely constitute a good faith effort with respect to this aspect of any employer's self-evaluation of its pay practices. Note that calculations, again, will look very different depending on the size of the employer. So, when there are differentials within a comparable work cohort, or again, group, the employer should then determine if the differential is authorized by one or more of the factors set forth in Rhode Island under the Pay Equity Act. We apply the authorizing factors in step 4, and we'll review those in more detail coming up. If differentials in pay for comparable work are detected and no authorizing factor applies, the employer can stop the analysis at that point and address the wage differentials. So, the focus of the third step is really twofold. One, to identify if there are pay differentials between comparable work, and then identify if there are potentially applicable authorizing factors that could justify the pay differential. So, one other thing to bear in mind is employers should also consider outliers, employees whose compensation is significantly out of line with others within a comparable work grouping to determine whether they are being paid in compliance with the statute. This most often is seen where there's either particularly high turnover or where there's a group of seasonal workers mixed in with non-seasonal workers who have similar job functions. Obviously, the seasonal workers may come and go as required, but those workers who stay all year round or for many years might have seniority and therefore have a higher wage. So now we're at step 4. So this is where we take a look at whether differences in pay for comparable work are justified under the new law. And there's really 8 factors to look at. So where a pay differential for comparable work is detected, regardless of the stage of the analysis, the employer has to determine if one of these 8 factors applies. Where possible, one thing an employer could do is assign a numeric value to each factor that's particularly relevant to the organization and the job being performed. For example, a merit system might be represented by performance ratings on a scale from 1 to 10. Employers using a statistical modeling methodology to analyze whether there exist broad-based authorizing factors, but there still has to be a showing of how the model accounted for all identified pay differentials. Basically, having the statistics and the modeling methodologies is great, but there still has to be an explanation of how the differentials have been identified and or justified. Where practical, employers are strongly encouraged to identify the relevant authorizing factor for each instant of differential rate of pay. Again, going back to my earlier example with the workers who are there all year round versus seasonal, a seniority system or a merit system is an authorizing factor. So that wouldn't prevent an employee who's been at ice cream shop or what have you for 3 years to be completely out of line with a seasonal worker. Again, if there's a pay differential identified, the employer can't reduce the wage of the outlying employee, but instead has to effectively raise the floor. I would suspect that in the food service industry, the seniority system and the merit system really would help, in addition to reasonable shift differentials, might be more important authorizing factors as opposed to, let's say, work-related travel. One of the other things to keep in mind is the eighth factor is somewhat of a catch-all, because this is the one of the only instances where the law realizes that not every employer is alike. And this isn't, these factors don't necessarily apply uniformly across the board. So by creating, the bona fide factor other than a protected characteristic that, excuse me, it has to be job related with respect to the position in question. And it also has to be consistent with business necessity. That's just a fancy way of saying if there is an additional factor that an employer wants to rely on, it has to be related to the job, it has to be related to the business, and it has to be related to the position in question.
Chris, we have another question. Anthony, do you want to go ahead?
Yeah, please. So in the event, as I have 2 locations within Rhode Island, and there's certainly other members that have multiple locations, is there any protection if they're under different corporate identities, or is this similar to the ACA where if you're a sole owner or the same owner of multiple units, that everything falls under that one umbrella?
So that's a really good question. The term, the definition of an employer is incredibly broad. I would say that if they're owned under separate LLCs, they're probably separate enough to where, one wouldn't necessarily have to conform to the other. And even so, if DLT disagrees with me, you can also look to the fourth authorizing factor, the geographic location. Let's say, one location's in Westerly, one location's in Bristol. There's going to be wildly different disparities just based on that geographical distinction alone. Excuse me. So step 5 of 6, we're almost there. Remediate any protected class-based pay differentials. So the remediation efforts has to be total, meaning that the pay of individuals subject to an unauthorized differential must be raised to an equal status of that one of the highest paid comparator. In addition, where one adjustment has the incidental effect of creating a new unlawful differential, the differential also has to be addressed. Again, a very fancy way of saying you can't reduce the highest person, you have to raise the floor. One method for avoiding this type of cascading differential creation would be to equalize pay across a comparable work grouping at the rate of the highest comparator. Again, this will wildly depend and vary from employer to employer and business to business. That really should be kept in mind. Any adjustments as a best practice should probably follow a very simple formula. For example, providing all affected employees the same amount or a percentage increase, or it could run the result of having a more targeted differential issue. All right, step 6. Employers that identify an unlawful pay differential between members of protected classes performing comparable work should try to figure out why the differential exists. For such differentials, for example, supervisor discretion, starting or historic salary raises over time, and take steps to prevent them in the future moving on. Because again, the self-evaluation really is to identify the issues, that have been created or put into motion in order to stop it from continuing in the future. Among other things, employers should consider implementing objective standards for setting starting salaries or hourly rates, and for applying raises and other adjustments. Employers should also consider making changes to job titles, description, codes, bands, grades, etc. Again, depending on the nature of the business and how the business is run, in order to better align with more comparable work cohorts or, again, groups. Finally, employers should consider conducting some form of self-evaluation on a regular basis, for example, annually, to ensure that disparities do not recur over time, because again, people are human. There's a grace period until 2026 to avoid liability. So, if, for example, an employer does a self-evaluation this year and next year and in 2025, and identifies disparities in all 3 years, they're better equipped to try to figure out the root cause of that issue while they're still insulated from all liability and damages, as opposed to doing it once in 2023 or once in 2024 and then trying again in 2026 and then realizing everything just got completely out of whack. So how does it all come together? That was one of my big questions that I was having. It's like, all this information is really great, but a visual aid is awesome. You guys might recall that I spoke about the spreadsheet that's freely available from DLT, and that's exactly what I'm showing you here. This is one of the examples provided by the spreadsheet to illustrate one way of compiling the information and looking at how it all comes together in terms of identifying differentials and authorizing factors and potential violations. Now, I know we're a little bit strapped for time, so I won't go through every single example on this list. But again, all the examples are freely available from the DLT the Excel spreadsheet, excuse me, that's available free for DLT. So, by way of—
one more question about this.
Sure.
Just confirming that these self-evaluation forms will not be collected by the state, but they're just good to have in case you're audited?
Yes.
Best practices? Thank you.
Yes, as a best practice, the state, there's nothing in the law that allows the state to collect it. However, and this is a point that I was going to raise a little closer to the end, although we're close enough already. It's very important to note that the Rhode Island Pay Equity Act does not necessarily preclude evidence of the self-evaluation from being admitted. Again, I don't mean to draw a jurisdictional difference, but the Massachusetts equivalent expressly bars the evidence of any self-evaluation in any type of proceeding. The Rhode Island version, unfortunately, isn't nearly as strict, but does say that no adverse inference can be taken against an employer for not doing it. And it also states that the fact that a self-evaluation was done and differentials were identified is not in of itself evidence of an unlawful wage claim. So again, that doesn't necessarily mean that the state will never be able to get it. If an employee makes a claim against the employer about an unlawful wage differential and the employer raises the defense of the self-evaluation, then it's very likely that the adverse party, or in the event of an administrative proceeding, the department will be able to get copies of what has been relied on. But I have a solution for that coming up. I just did want to, do one run through of one example, just so that way anyone can understand how everything comes together. So, for example, looking at this spreadsheet, employee number 2 and employee number 4 earn more than employee 1 in the same job class without any authorizing factors to justify the pay differential. While taking that into consideration, the potential violations are flagged. So as you'll see, and again, you're not required to use this spreadsheet. You can use whatever spreadsheet you want, but I think starting out like this is really helpful. So here the spreadsheet identifies the potential violations based on the information calculated. And as I mentioned earlier, the spreadsheet will do the calculations for you.
Chris, which of those jobs are comparable?
So, So employee number 2 and employee number 4, I believe, director of DEF and director of JKL. Again, unfortunately, not much information is really provided regarding what goes into these because they're all under a manager type category. So this is looking at one snapshot of a very specific category and wage disparities within that specific category. So the issue flagged here between employee number 2 and employee number 4 is the $65,000 salary made by number 4 in the same position as a manager and a director when compared to the base compensation of employee number 2, which is only $60,000. Neither of them has an authorizing factor to explain the wage differential of the $5,000. That is why it becomes flagged. Does that make sense? I hope so.
Thank you.
Yep. Okay, so we jumped the gun a little bit a moment ago, but unlike other states, Massachusetts, the Rhode Island Equal Pay Act doesn't prohibit evidence of the self-evaluation proceeding. Employers should consider retaining counsel to perform a privileged audit before proceeding with a non-privileged audit. Effectively, a privileged audit would involve retaining outside counsel to do a self-evaluation. That way, the employer can take those results and do a non-privileged audit. And if there's any bad information that shows up on the first one, that would, in theory, be covered by the attorney-client privilege because you retained outside counsel for the express purposes of doing a wage audit for you before you take matters into your own hands. It's not required by any stretch of the imagination. But as a best practice tip, or if somebody's particularly concerned, it might be a good safety net in the event that there are potential disparities that come up. I would imagine that that recommendation would be more appropriate once the June 30th, 2026 timeline for the complete defense elapses, at which point an employer will be liable, but a good faith self-evaluation could still ward off damages. Again, an employer who has not completed a self-evaluation shall not be subject to any negative or adverse inference as a result of not having completed self-evaluation. But so an employer doesn't lose anything by not doing it, other than the potential to raise an affirmative defense built around that. That's expressly allowed in statute. So if you're able to do it, I would very much recommend it. And that's it. If you have any questions, feel free to reach out. I know Bob Brooks is very active with Rhode Island Hospitality as well as so of course, if you have his contact information or you work with him, I'm sure he wouldn't mind being reached out to in connection with this.